Good morning, everybody. Magandang umaga po sa ating lahat. Can you hear me? I would just like to check if I'm coming in clear.
Yes, Ms. Camille, clear po.
Thank you. Welcome, everyone, to the forum on the online dispute resolution system. Today is a very important day. No, but before we begin, we would like to give some reminders. Firstly, please be informed that this forum is being recorded. And by continuing your participation in this session, you are consenting that you may be recorded. Otherwise, you may choose to no longer join. But of course, we encourage you to please stay with us until the end of the forum. So I'm Camille Castillo from the DTI Consumer Policy and Advocacy Bureau of the DTI Consumer Protection Group. We are very fortunate to have very important people to join us here today, distinguished personalities, no? From the government and of course from our partnership, from the private sector and the NGO. For our opening messages, I would like to call on first Mr. J. De Quiros, the Economic Growth Specialist from the United States Agency for International Development. Mr. De Quiros has a balanced set of skills, knowledge, and experience, especially in the areas of competitiveness, investment, trade facilitation, enterprise and value chain development, urban development, local governance, and poverty reduction. He has proven himself on a range of functions from technical and capacity building and facilitating local sustainability and such as mentoring local governments, private sector, and civil society, to communication, such as writing reports, briefers, preparing decks, and delivering presentations. Good morning, Mr. De Quiros. The virtual floor is now yours.
Thank you, Camille. Magandang umaga po sa lahat. Thank you very much to DTI for organizing the event. Let me start off by making a few acknowledgements. First, our key partners without whom none of this would be possible. So, of course, si Yusef Ruth Castello, DTI, and of course, ASEAN Kabochan, DTI as well. Mark Calimon from Sumbing Torres, Dr. Henry Basilio, Dr. Lamberta, and the rest of the Respond team, like UPAF. And of course, Craig Blakely. Hi, Craig, our consultant at the USAID Pro ICT project. So I represent the United States Agency for International Development, or USAID for short. USAID is the lead U.S. government agency for international development and humanitarian assistance. This month, USAID is proud to celebrate 60 years of helping people around the world build stronger, resilient, and more prosperous communities. USAID was founded in November 1961 by President John F. Kennedy. The Philippines was one of our very first partners countries. Today, USAID works in more than 100 countries worldwide, but the Philippines remains a key partner in promoting sustainable and inclusive development in the region. For the past 6 decades, we have collaborated with the Philippine government, private sector, and local organizations to improve everyday lives, investing more than $5.1 billion towards shared development goals since 1961. Now, I wanted to emphasize the importance of this initiative being spearheaded by DTI. It may already be cliche at this point, but truly the pandemic had accelerated Filipinos' adoption of e-commerce and a shift to online modalities, from banking all the way to learning through online classes. I was told the number of locally registered online businesses surged from 1,700 before COVID-19 to 75,000 in just a little over 5 months into the pandemic last year, 2020. While online transactions make life easier, especially under community quarantines, many unscrupulous sellers saw the opportunity to goods, trick customers into believing they really had the merchandise, or just didn't care to provide good service. In 2019, consumer complaints were only roughly 2,500. The following year, it ballooned to more than 57,000, with the bulk of that composed of online complaints. USAID is pleased that Respond, which we are funding, is supporting the development of the Philippine Online Dispute Resolution System, or PODRS. And I believe both the system assessment and the functional specifications workshops have been completed. We thank DTI for welcoming Respond's assistance. With the PODRS, the Philippines also further responds to the ASEAN Strategic Action Plan on Consumer Protection for the post-ASEAN Economic Community 2025, which aims to institute a higher consumer confidence in AEC and cross-border commercial transactions. Not only will consumers be able to easily file complaints, but we think the system will also dissuade online scammers in the future. We would also like to acknowledge the expertise of Craig from the USAID-funded Pro ICT project. USAID tries to leverage its presence in over 100 countries by collecting and distilling best practices that can inform local initiatives. Craig will be talking about international and regional perspectives on online dispute resolution. Thank you as well to Mark, will provide a broader national perspective. We value inputs, of course, from the well-respected Kisumbing Torres firm. I look forward to learning more about the system and the inputs from all our speakers today. Again, thank you to Yusek Castelo and the team for your vision, leadership, and hard work to making this possible. Maraming salamat.
Thank you, Sir De Quiros, for that very warm message. Now, for our second opening message, she is the Undersecretary of the DTI Consumer Protection Group. She has been at the forefront of this project several years ago. And I can remember pretty well how she was able to push this in the ASEAN Committee on Consumer Protection. Ladies and gentlemen, please welcome our efficient and tireless Undersecretary, Attorney Ruth P. Castelo. Good morning, Yusek.
Oh, hi, Camille. Thank you very much. Hold on. Let me just... Okay, good morning, everyone. And of course, thank you for being here today. On behalf of the Department of Trade and Industry, it is a pleasure for all of us to welcome you in today's forum on online dispute resolution system. We acknowledge, of course, Dr. Enrico Basilio, the Chief of Party of the UP Public Administration Research and Extension Services Foundation Incorporated, or the UPAF, and then the Regulatory Reform Support Program for National Development, that's RESPOND. Mr. Mario Lamberte, of course, our team leader, the one who has been pushing all of us. Without his patience, we will not be here today. Our distinguished speakers, my friend and classmate, Attorney Don Mark Calimon. Welcome to this webinar forum, whatever we call this, and Mr. Craig Blakely. All our participants and partners in consumer protection, magandang umaga po sa inyong lahat. Please allow me to start by expressing our sincerest gratitude to UPAF RESPOND for organizing this forum, and of course to USAID for funding, for providing assistance for this project. In the face of unprecedented advancements in the digital economy, online dispute resolution systems are gaining traction and relevance across the globe. Its prominence is reinforced by the need and demand to create cost-efficient, user-friendly, practical, and convenient systems which employ digital technologies so that we can facilitate consumer access to redress. We are all aware of the benefits that the digital economy offers to consumers, primarily because of convenience and cheaper costs. Digital economy has grown exponentially and is expected to grow further. Its dynamics has brought extraordinary changes in the consumer behavior and business landscape, which has resulted, however, in the increasing number of consumer protection issues and concerns. We have been receiving a lot of this in the Consumer Protection Group Fair Trade Enforcement Bureau. And so there is a need to establish a more robust and efficient mechanism that would provide adequate facilities and systems in seeking consumer redress. Acknowledging the need for tapping on technology to provide consumers better access to redress, the DTI is developing the Philippine Online Dispute Resolution System, which is intended to streamline and improve existing complaints handling procedures so that we can later on have this integrated into the ODR systems of other countries, particularly with our neighboring countries in the ASEAN. This is also one of the ASEAN projects that the Philippines is pushing. And we hope that all other countries in the region would have this system so that we can all have them integrated into just one ASEAN ODR system. Envisioned to serve as a primary online mechanism through which complaints involving both offline and online transactions would be lodged, the PODRS shifts a manual to automated referral system based on the harmonized standards across national government agencies with consumer protection mandate. In the Philippines, we have the the ICT, NTC, the National Telecommunications Commission. We hope that the Department of Health and the Department of Agriculture would also have this. We would also probably want to link with the Bureau of Customs and the Philippine National Police. They have they also receive complaints, consumer complaints, and then they refer it to the DTI for resolution. To date, the development of the PODRS pilot project was in phase 2, which is the finalization of the most feasible functionalities that could be employed in the system. It is in this regard that today's forum is very timely and of high significance for the DTI in relation to its development of the PODRS. Our distinguished speakers are here to provide us with national, regional, and international perspectives relative to online dispute resolution systems, of course, with a view of providing practical insights and best practices on ODRS. It will assist us in ensuring that we are on the right track in developing our own national ODR system. This forum also aims to gather additional inputs which could contribute in the development of the Philippine online dispute resolution system. And that is why we highly encourage everyone to actively engage in today's event. Please provide us your comments and inputs that will be highly valuable in ensuring that the PODRS will be a success, and so that it will serve its purpose to provide an efficient facility for consumer redress, and so that eventually we can provide greater confidence when making commercial transactions locally or internationally. We thank all of you for being here today. We really hope to have everybody engaged and actively participate in this forum today. And of course, before I end this message, let me, of course, acknowledge our equally tireless Assistant Secretary Ann Claire Cabochan. We also have Assistant Secretary Ronel Abrenica, who oversees the enforcement portion of our functions in the Consumer Protection Group, and the Consumer Policy and Advocacy Bureau that leads this project for the DTI, headed by Director Attorney Marcus Valdez, Attorney Cheryl Carbonell, the Assistant Director, and of course the Division Chief of the Advocacy Division, Camille Castillo, and everybody, the men and women behind this project, to USAID, to UPAF, Respond, Dr. Lamberto, the faces, I'm looking at the faces here, Jobel, basta the team of Sir Mario, of course, Dr. Basilio, everybody behind this project. We really hope that we can push this. I remember in one meeting with the team of UPAF, I was asking if we can possibly finish phase 2 by the end of this year, so that we can proceed with phase 3 immediately and then have this launched sometime in March 2022. I hope that is possible. I see Dr. Basilio nodding his head, so we can probably proceed with this timeline. Okay, thank you, Dr. Basilio. Maraming salamat po sa inyong lahat. Thank you very much for joining us here. Magandang umaga po.
Thank you, Yusek Ruth. Maraming salamat po. And together with UPA, Dr. Mario, we take on the challenge that we are targeting by March 2022. Dr. Mario is smiling. I hope that's a very big yes. All right. For our third opening message for this morning, I would like to call on, of course, another very important person in the project. Hold on. Well, he is the Associate Professor of Public Administration and Economic Development at the University of the Philippines National College of Public Administration and Governance, or UP-NCPAD. He is the director of the UP Public Administration Research and Extension Services Foundation Incorporated, or UPAF, and he is the chairman of the Export Development Council Networking Committee on Transport and Logistics. He is the senior advisor, Transport and Logistics Committee of the Philippine Chamber of Commerce and Industry. Let's welcome everybody, Dr. Enrico Basilio.
Okay. Yes. Thank you, Camille. Can you hear me? Yes. Am I coming in loud and clear? Yes. Thank you. Okay. So to our friends from the Department of Trade and Industry, starting off with Undersecretary Ruth Castello. Ma'am, to your question, I'm already committing the team of Dr. Mario Lamberte to move heaven and earth to finish it by the timeline that you have set. Okay. To Assistant Secretary Ann Cabochan and Assistant Secretary Ronel Abrenica, our friend and our project officer from USAID, J.D. Quiros. To our speakers this morning, we have two lawyers actually, Don Calimon and Craig Blakely. Of course, Dr. Mario Lamberte, the man of the hour, the Respond team leader, and other team Respond team members who are here present. Also to the DTI team members who have been working with us on the development of this system. Friends and participants, good morning. Magandang maga po sa kanilang lahat. So again, I'm Henry Basilio, the Chief of Party of the Respond Project. Respond stands for Regulatory Reform Support Program for National Development. It is a project being implemented by the UP Public Administration Research and Extension Services Foundation and supported, of course, by the United States Agency for International Development. The overall goal of Respond is to improve the environment for trade and investment by making the economy more open and competitive. And together with our government partners, Respond pursues policy and regulatory reform initiatives to enhance market competition, improve regulatory quality and governance. So Respond is a very strong partner and supporter of the Department of Trade and Industry, and we've been collaborating for many years now on various programs and activities aside from the development of the PODRS. So the sharp rise in online business transactions because of the pandemic was accompanied by an increase in complaints received by DTI. Hence, there was a need felt to develop an online dispute resolution system that would address this concern. The system's overarching goals are to increase accessibility to redress for a wider consumer base, offer a fast, simple, and low-cost method for redress, and enhance consumer confidence in online transactions. Likewise, PODRS now, as mentioned by Camille earlier, is the country's program that serves as our contribution to Strategic Goal 3 embodied in the ASEAN Strategic Action Plan on Consumer Protection for 2016-2025, which aims to institute a higher consumer confidence in the ASEAN economic cooperation and cross-border commercial transactions. So let me end this short message by thanking again Undersecretary Castello for the opportunity given us to co-develop the PODRS and work closely with the team of ASEC Cabochan and of course Camille. Special thanks to USAID for supporting the activities of Respond. Let me also thank our partners on e-commerce here with us who will share their vast knowledge and experience on e-commerce, Craig Blakely and Don Calimon. And finally, let me acknowledge the valuable contributions of the DTI Respond team. So this is a composite team already because the approach is co-development. So it's not only Respond extending technical assistance, but it's really our partner agency from DTI who's collaborating. The men and women who work tirelessly and diligently to ensure that this PODRS would protect and enhance the confidence of consumers in online transactions. So thank you, Dr. Mario Lamberte, for taking on the task of leading this effort from the side of Respond. I'd like to also to acknowledge Roy Marzan, Cheryl Bunag, John Montoya, Poch Tan, Jobel Alzate, Paulo Fernando, and Miriel Damsani, who have helped and assisted Dr. Lamberte. From the DTI side, the contributors include ASEC Kabuchan. Of course, the guidance, the overall guidance is provided by USEC Ruth Castello, no? But ASEC Kabuchan, and also the rest of the technical team led by Camille Castillo and Alex Carandang from the Consumer Protection Office. So I'm sure that we will have a very exciting forum this morning. So maraming salamat po, at again, magandang umaga po sa kanilang lahat. Thank you.
Thank you, sir. Thank you, Dr. Basilio, for those encouraging words. And we are very happy. In fact, the DTI sustains its enthusiasm, no, to finally end our phase 2 and start with phase 3. Okay, now we need to document this. Let's have a photo opportunity. May we request everybody to turn on their videos. Jobel will be taking our screenshot of our assembly for today.
Okay po. In 3, 2, 1, smile. Okay, one more po. May nag-open pa po ng camera. In 3, 2, 1.
All right. Thank you, Jobel.
Oh, si Roy wala sa photo.
Okay.
Sayang. Roy?
Again.
I forgot to mention Roy. Thank you very much. And of course, Jay De Quiroz. I mentioned USAID, but I think I missed your name. Thank you. Thank you for the assist.
No worries, USEC.
Alam mo, Yusek, hindi lang ikaw ang senior moment. Ako rin. Kasi nandito rin pala si Ernest, si Buboy Oxon. So, Buboy.
Hello po. Good morning, everyone. Doc Henry, Yusek.
So, Jobel, are we done?
Yes.
Okay po. Isa pa po kasi si Sir Roy. Okay. 3, 2, 1. Quick na lang po. In 3, 2, 1. Okay po.
Okay.
All right. Thank you, Jobel, and thank you, everybody.
Thank you.
We just had our very encouraging messages from our very important principals, no, for this program. Thank you very much for all the support, sir, ma'am. You know that we will not be able to proceed as we planned without your guidance, without your push. And of course, without ensuring, no, that we all have the resources that we need for this project, the Philippine Online Dispute Resolution System. Thank you very much, everybody. Now, we are now in the second part of our forum, and we will be having our proper presentations for this morning. Now, we have two very important speakers for the online dispute resolution system. Okay, let's proceed. Hold on. So let me just remind everybody that this Philippine Online Dispute Resolution System, particularly this forum, is a partnership of the DTI Consumer Protection Group and the University of the Philippines Public Administration Research and Extension Services Foundation, Incorporated, Regulatory Reform Support Program for National Development, or UPAF Respond, no, through the United States Agency for International Development, or USAID. This forum is in line with the preparation of the final document, no, for the functional specifications, or phase 2 of the Philippine Online Dispute Resolution System. We are really excited about the almost end of the phase 2, so we can easily proceed with our phase 3. And we are very happy that each one of you was able to contribute with us. In fact, we have several workshops that we were able to conduct for the phase 2, which has led to us this forum, and finally the report, no, by this December. So we're still working, of course, actively with Sir Roy, Ms. Cheryl, and the DTI team will, of course, fully support, no, this program for us to finalize phase 2 and then proceed with phase 3. All right, now for our first speaker for this morning, We will have the overview of the Philippine Online Dispute Resolution System. Our presenter is another staunch supporter of this program, of course, from the DTI Consumer Protection Group. Let us all welcome the effective and efficient Assistant Secretary of the DTI Consumer Protection Group, Attorney Anne Claire Cabuchan. Ma'am, the virtual floor is yours. Thank you. Thank you, ASEC.
Thank you, Camille, and good morning, everyone. I would just like to make a very fast acknowledgement, of course, of our partners in this project. Thank you for being here. USAID, Dr. Quiros, from UPAF Respond, Dr. Basilio, Dr. Lamberte and his team, Roy, Cheryl, Joe Bell, Buboy, who are also here. My fellow presenters, acknowledged experts on alternative dispute resolution, Attorney Don Calimon, of course, Attorney Craig Blakely, and of course, my colleagues from the Consumer Protection Group, ASEC Ronella Brenica, and Director Marcos Valdez, Assistant Director Cheryl Carbonell, on behalf of the Consumer Protection Group led by USEC Ruth Castello, allow me now to present the overview of the Philippine Online Dispute Resolution System. The Department of Trade and Industry, through the Consumer Protection Group, led by the Consumer Policy and Advocacy Bureau, begins the pilot run of the Philippine Online Dispute Resolution System to start up the country's improved online system to receive and resolve consumer complaints. Next slide. Republic Act number 9285, or the Alternative Dispute Resolution Act of 2004, was enacted, and Section 2 sets forth the policy of the state to encourage and actively promote the use of alternative dispute resolution as an important means to achieve speedy and impartial justice and declog court dockets. So under the Section 2, the state really provides to the parties autonomy in the resolution of their disputes and the freedom of parties to make their own arrangements to resolve their disputes. So under the ADR, parties are free to choose from a variety of mechanisms. Next slide, please. It could be through mediation, arbitration. Next slide, please. It could be through mediation, arbitration, and other means. So here in our project on the PODRS, as stated by the previous speakers, this is really one of our commitments under the ASEAN Strategic Action Plan on Consumer Protection, which is within the purview of the ASEAN Committee on Consumer Protection. And the deliverable really here is to establish an online dispute resolution system. That is the previous slide. To institute high consumer confidence in the ASEAN economic community and cross-border commercial transactions, in which all the 10 ASEAN member states must establish their own online dispute resolution system. And when all of these states have already have established their own systems, it will be integrated into one ASEAN online dispute resolution system, which would make really the manner in which any complaints or grievances are resolved more expeditious, speedy, and of course at low cost. ASEAN being, of course, a single market and production base, it makes sense to have something like this. Next slide, please. The DTI, therefore, proposed through this Consumer Protection Group the implementation of an PODRS, and this is embodied in Department Administrative Order 20.05, which is on the development of a PODRS. It was issued in September of 2020, and the purpose is to establish an integrated national online system by which all consumer complaints are received, docketed, transmitted, and resolved, providing a network facility and limits of disclosure of data to maintain integrity and credibility of the system. So if you look at the bullets there, it says it is applicable to all consumer complaints. The system ownership is with the DTI. And of course, the DTI will pilot the PODRS, but will encourage other members of ConsumerNet to eventually use the system. So we will have one system of resolving consumer complaints across all consumer protection agencies. And there is an adherence, of course, to Republic Act 10173, which is the Data Privacy Act. Next slide. There are a variety of alternative dispute resolution mechanisms. What we are using here under the PODRS is mediation. At this time, in fact, mediation is already a compulsory process in our resolution process for consumer complaints. So when we receive consumer complaints, the parties will have to go through mediation with the hope, of course, that through mediation, the issues are resolved. So what we are choosing is mediation. So for this particular process, as well as for conciliation and assisted negotiation, and they are consensual in nature, although there is a neutral third party that facilitates communication between the parties to help them reach an agreement. So as it stands right now with the Consumer Protection Group, the Fair Trade Enforcement Bureau has a mediation division. And so that is the mediator there would be the third party facilitator when there is a complaint. Arbitration, on the other hand, it is an ADR mechanism, but of course it is adjudicative in nature, and the neutral third party gathers information from both parties and makes a decision that is often intended to be legally binding and final. So next slide, please. What is the importance of ADR in consumer redress? It offers consumers with a quick, effective, and inexpensive way of resolving a complaint, and taking away, of course, the burden and expense of a formal legal action. So there are so many lawyers in the room, but we all know and we acknowledge that when you go to court, it is a long process and it is an expensive process. And if you can resolve it through mediation, which would take a shorter period of time and less expenses, I think that really, even if I'm a lawyer myself, I would choose to go through that route rather than going through a really expensive process. There is autonomy of proceedings when you talk about mediation. So there is an article 4.5 of the IRR of the ADR Act that says no court shall intervene except where so provided in the ADR Act. So a mediator may not make a report, assessment, evaluation, recommendation, or finding or other communication regarding mediation to a court or agency or other authority that may make a ruling on a dispute that is the subject of mediation under Section 12. Of course, the cost is significantly less than going to court. And if, when you go to court, there are a lot of technicalities, what we call the rules of court. So the parties will not be so constricted by those technicalities, and the time to resolve a dispute through ADR will be relatively really less costly. In fact, it is also the state's policy to have prompt, economical, and amicable resolution of disputes. The courts will always have, their role to play in the dispensation of justice. But of course, when you say ADR, there are also complaints that if they go through the ADR process would be more expeditiously handled. Convenience of the parties are free to agree on the place of mediation. Failing such agreement, the place of mediation shall be at any place convenient and appropriate to all parties, and there it is more likely to preserve existing relationships because the parties themselves make the arrangements to resolve their disputes. So then you're able to really preserve those relationships. There is also confidentiality. Such processes occur behind the privacy of closed doors and not within the public sphere as when you are in court. And given that the importance of confidentiality in the proceedings, information obtained shall be privileged. And the enforceability of the mediated settlement agreement, if the mediation is successful, the parties themselves shall prepare that agreement, although they may be assisted by counsels, or if any, or the mediator. And this shows the importance given by law to resolve conflicts by parties by giving them the liberty to reach out to an amicable settlement. So considering the advantages and benefits provided by law, ADR is a quick, effective, and inexpensive way of resolving disputes. Next slide, please. An effective ADR is applicable to all types of transactions. It enables three-way communication between the consumer, the business, and an ADR provider. It is user-friendly, and it must be trustworthy. So when you say trustworthy, it is accessible, fair, independent, transparent, effective, and timely. So next slide, please. So as we have been, next slide, please. So our goal is to establish a central online facility for consumer redress, reinforce interagency coordination, harmonize the complaints handling processes of government. So the next slide. Now, there are three phases to the PODRS. The PODRS assessment has been completed. PODRS functional specifications and workshop. If you look at the slide there, the cloud is almost full, which means that we are in the process of completing that. The team is working hard to complete it, given the timeline. Undersecretary Costello had earlier said by March of 2022, we would like to look forward to phase 3 being completed in that first quarter. So next slide, please. So this, of course, is our UPAF Respond team, and we would like to really thank them sincerely for all the guidance and, of course, the leadership in helping us out with all these, especially the very technical aspects of the project. We could not have done it without them, Dr. Lamberte, Sir Marzan, and Ms. Bunag. So next slide, please. For phase 1, there has been an Inception Report that was presented to the Consumer Protection Group that was dated March 1. And of course, for phase one, that is the functional, for the phase one, that would be, of course, our assessment. So the PODRS assessment, so it went through that process of consultation with various offices within DTI. So next slide, please. We also had in early March of this year, the creation of a technical working group to be able to really push this project. Next slide, please. Now I go to the features of the PODRS. So what we envision the PODRS to be: well-defined parameters and scope, simple, user-friendly, fast, reliable, and flexible. We are talking here of users, those consumers who would like to complain from all walks of life. So we would want it to be really user-friendly and, of course, reliable. Multi-platform accessibility, very important at this time as well. There should be a referral, status monitoring, and feedback capability. And we acknowledge that this is the part that under our present setup, we need to really work on, especially on an interagency level. The generation of analytics of the kinds of complaints, the statistics that would really be very good for policy making and also assessing how we perform our work in consumer protection. Three-way communication, information, and education section, which is very much a part of consumer protection, being able to really get the information out there, to be able to reach out to more people. User login and multi-factor authentication, electronic submission and transmittal of documents, and the bilingual option. So next slide, please. Okay, so we were done with, well, we had shown this already earlier, the phases. So we can go to the next slide. And this is the Inception Report that was already flashed earlier. Next slide, please. There were a series of focus group discussions that were conducted. Actually, there were a lot of agencies that are part of ConsumerNet, even consumer organizations and online platforms that participated in the discussion. So what are the recommendations from these FGDs? These are the recommendations. All adjudicated cases should be viewable online. A single point of contact should be established for all consumer complaints. So that would really make it user-friendly. Report and statistics should be accessible to stakeholders. The system should be able to consider the privacy of the mediation process. Of course, that is acknowledged even under the law. Integration with ConsumerNet and respondents, and ConsumerNet access across to the PODRS. Digital documents available in the system, which makes sense right now when everything has gone digital. We should also be able to evolve to the digital documents. That is also something that under the regular courts is being done. Accessible to the DTI regional and provincial offices, SMS email notifications sent to concerned parties, escalation to the respondents first before mediation, and an online meeting platform for mediation. So these are the recommendations from all those FGDs. Next slide, please. And the discussions also yielded additional features to the PODRS, which is not in the Department Administrative Order on the development of the PODRS. So These are the additional features: work list and workflow automation, mediation tools, a dashboard, notification and alerts, a feedback mechanism, polling, consumer profiling, a document management system, search facility, linking of tickets, service level management, and problem management. So next slide, please. There are also other recommendations, and the recommendations being to be leveraged on cloud technologies, data analysis, remove call center dependencies, and off-the-shelf, or off-the-shelf it's self-service, and enhanced notifications, problem management, reports, collaboration, linking of tickets, automation of routine tasks, feedback mechanism, and integration. So next slide, please. So under the PODRS functional specifications, requirements gathering workshop, there were 9 sessions, and the kickoff meeting was last August 19. So the attendees were mostly, of course, DTI, consumer net agencies, consumer organizations, and respondents. So these are also the schedule. So up to this is now where we are at. The presentation of in November 19 would be the presentation of the final report under phase 2 of the PODRS. Next slide. So what is the ways forward for these projects? Presentation of the phase 2 report to the Consumer Protection Group Management Committee, and after which we will be ready to start with phase 3. Phase 3 is divided into 2 components. You have the PODRS compliance, which would be compliance to data privacy, to security, and to risk management. And the second component being the PODR systems development. So as we said, we first launch it within DTI and hope that the other agencies within ConsumerNet will also be part of it in the near future. So with that, thank you very much for your attention.
Thank you. Thank you very much, ASEAN, for breezing us through the Philippine Online Dispute Resolution System. I hope that most of us are now very much aware of where we are in this project and how we will proceed for this project. May I just share with you that for the PODRS, the DTI has an expanse team in ensuring that the project proceeds as planned and will be accomplished. We have, of course, the DTI Regional Operations Group. We have more than 100 regional and provincial officers who have been giving us their inputs and who have been commenting on the activities, on the documents that we have for the PODRS. Of course, we also have the Knowledge Management and Information Service Office, the Information System Management Service Office, and the Legal Service Office. Then for the DTI Consumer Protection Group, our frontline for consumer protection, the Fair Trade Enforcement Bureau, and of course, assisted by the Bureau of Philippine Standards and the Consumer Policy and Advocacy Bureau. Now we're off to our second presenter for this morning. The presentation is on the online dispute resolution, a national perspective. Our speaker is a partner in Kisumbing Torres Dispute Resolution Practice Group and heads the Industrials, Manufacturing, and Transportation Industry Group. He has more than 19 years of experience in dispute resolution, including civil, criminal, corporate, and regulatory litigation, and commercial arbitration. He is one of the founders of the Philippine Institute of Arbitrators and is a member of the panel of arbitrators of the Singapore International Arbitration Center, the Philippine Dispute Resolution Center, and the Philippine International Center for Conflict Resolution. He is also an accredited arbitrator of several Philippine arbitration institutions, including the Wholesale Electricity Spot Market and the Intellectual Property Office. He is presently serving as the Secretary General of the PICCR, an alternative dispute resolution center set up by the Integrated Bar of the Philippines to provide arbitration and ADR services and facilities. He also represents the Philippines to the ASEAN Business Council. Let us all welcome, please, Attorney Don Mark Kalimon.
Thank you very much, Ms. Camille. May I just check if the audio is clear?
Loud and clear, sir.
All right, thank you, Ms. Camille. And again, I would like to thank the organizers of this event for having us. It's an honor to be here. When I received the invitation, and as mentioned earlier, I'm partner at Kisumbing Torres Law Office. But when I received the invitation, I readily accepted it, not only from the perspective of my being a practitioner, a partner in a law firm, but also because of my involvement in various ADR organizations. As mentioned by Ms. Camille, I'm active in the Philippine Institute of Arbitrators. I'm an accredited arbitrator of the PDRC, and also I'm presently serving as Secretary General of the PICCR. And the reason why I'm very active in all these organizations is because ADR is really one of my advocacies. And when we were requested by the Integrated Bar of the Philippines to help set up the Philippine International Center for Conflict Resolution, PICCR, I knew it will be a difficult task, but because of the objective, which is quite similar to one of the main objectives of the PODRS, one of our objectives is really to help the IBP, help the Supreme Court declug court dockets. And because of the relationship between the IBP and the PICCR, we're trying to leverage the national presence and structure of the Integrated Bar of the Philippines to use or to help promote the use of ADR, not only arbitration, but also any types of ADR in the resolution of disputes throughout the Philippines. So I'm really very excited with this development that the DTI is spearheading. I believe that the implementation of a PODRS will greatly help in declogging court dockets. And if any of the organizations I mentioned would be able to help, I think they would be really happy to collaborate with and support the efforts of the DTI. Okay, so let me just share my presentation. It's a very short presentation. I'm mindful that I have 20 minutes to present. So what I did was to limit really my presentation to what I think might be topics of interest for the DTI and the Respond team, the USA team, insofar as developing the PODRS in the Philippines, particularly in relation to its phase 3. So the topic that was assigned to me was the national perspective. So I thought it might be, I guess, although ASEC Anne has already given an overview of the Philippine ADR legal framework, I will supplement that and also in presenting my slides, offer some thoughts on what may be further considered in relation to the PODRS vis-a-vis the ADR framework of the Philippines. Let me start by saying that our ADR law, as mentioned by ASEC Anne, the RA 9285, is a very progressive piece of legislation. In fact, it is one of the, I think, most consistent with international best practices insofar as ADR laws globally are concerned. And so I would readily say that our ADR law would very much cover and support the development of a PODRS. So there's no problem in integrating or harmonizing the PODRS with our ADR law. I think there may be some jurisdictions or states which do not have the same kind of ADR law that we have, that would perhaps need significant amendments or modifications to enable the use of an online dispute resolution system. But our ADR law is quite progressive in that sense. So there's no, I don't see any difficulty with a Philippine online dispute resolution system being put in place and being in harmony with our ADR law. Okay. Okay. So for the next 15 minutes, I would like to talk about three particular areas. Number one, online dispute resolution under Philippine law. Okay, so just a brief background and context to the second and third topics. The second one is, I would like to give some distinctions, or at least explain some distinctions between commercial and administrative ADR under Philippine law, as I think it might be something that would be of interest insofar as developing the PODRS is concerned. And then finally, I would offer some thoughts for the consideration of the DTI and team respond insofar as the PODRS is concerned. Okay, so just, there you go. So I was looking at, so I had to also review the issuances of the DTI, and I looked at the definition of ODR under Article 2, Section 1.7 of DAO 20-05. And it defines ODR as any system of alternative dispute resolution that uses the internet or ICT to facilitate the resolution of disputes between the parties. Okay, so my takeaway from this is that ODR is consistent with how ODR is understood in other jurisdictions, is that ODR is part of or a branch of ADR or alternative dispute resolution. So we are envisioning an ODR system that would be part of the efforts of the Philippine government to promote alternative dispute resolution. Okay, so that's what I took away from the PODRS. Now, being an ADR mechanism, it would also be good to look at what ADR means under Philippine law. So when we look at RA 9285, ADR is defined as any process or procedure used to resolve a dispute or controversy other than by adjudication of a presiding judge or officer of a government agency as defined in the Act, in which a neutral third party participates to assist in the resolution of issues. So ADR includes arbitration, mediation, conciliation, and any other combination thereof or similar methodologies. Now, as you can see, this is broad, the definition of ADR. And as mentioned earlier, it can include dispute resolution mechanisms which are administered online. Okay. But what I wanted to point out is that under RA 9285, ADR is contemplated to be an adjudication or a resolution of disputes through a neutral who is not a judge or an officer of a government agency. Okay, so that's, I think, a nuance that should be borne in mind when we speak of ADR or even ODR, because if we want an ODR system that is or that will be considered ADR under 9285, then we have to be mindful of this definition of ADR under RA 9285. Okay. Now, as mentioned by ASEAN, there's no question that the state promotes the use of ADR. In fact, it encourages the government to actively promote the use of ADR as a means to, again, declug court dockets. So obviously the PODRS is consistent with the policy of the ADR Act. Now, so when we speak of this policy it seems to me that what the ADR Act is or seeks to promote is ADR as defined under 9285. And as I said earlier, the definition of ADR under 9285 seems to be restrictive in the sense that it refers to ADR administered by private neutrals. Okay, so that's why I came up with the term, or it's not really my term, but I used the term commercial ADR to refer to ADR under the ADR Act of 9285. So when we speak of commercial ADR, I am referring to ADR systems or mechanisms that are administered by private neutrals. Okay. However, as I mentioned, the ADR Act encourages the government to promote ADR, and again, as defined, it's commercial ADR. But does that mean that other forms of ADR, which are not commercial, are not being encouraged, or is not part of the government strategy? Not necessarily, because if you look at, okay, so these are additional parts of the policy. So if you look at the last policy under Section 2 of 9285, the state is also encouraged to enlist active private sector participation in the settlement of disputes through ADR. Okay. Now, insofar as administrative ADR is concerned, so here ADR which are administered by judges or by government officials, we can refer, for example, to EO number 97. So all agencies shall continue to promote the use of ADR in resolving disputes filed before them. Okay. So when I was looking at EO 97, I was trying to figure out, is EO 97 referring to commercial ADR or administrative ADR or both? But if you look at the whereas clauses of EO 97, it refers again to RA 9285 or the ADR Act of 2004, which again suggests that EO 97, number 97, might be again seeking to promote commercial ADR. Okay. And then I looked at the one of the whereas clauses of DAO 20-05 and saw that the objective, and as mentioned, I think this was also mentioned earlier, of the PODRS is consistent with strategic goal number 3 of the ASEAN Strategic Action Plan. Okay, and it aims to institute consumer confidence through the establishment of online dispute resolution systems. Okay, now what kind of ADR mechanism is the ASEAN looking at? So I looked at this one. In February, I think, of 2021, the ASEAN released the ASEAN Guidelines on Alternative Dispute Resolution. Okay, so I believe that this document was prepared with a view to making suggestions to the various ASEAN member states as to what should be considered in the development of their own PODRS. And the reason for this is because the ultimate objective of the PODR of the ASEAN is to have a region-wide online dispute resolution system that can be interlinked or integrated, or that can work complementary to one another. Okay, so I think it's also good to be mindful of these guidelines, because other ASEAN member states might be looking at these guidelines for purposes of their own PODRS. And these are some of the, or at least these are the 10 main guiding principles identified in the ASEAN ADR guidelines. For example, one item there would be party autonomy. And as mentioned by ASEAN earlier, in relation to mediation, for example, party autonomy is also emphasized, because the ability of the parties, for example, to choose who will help them resolve their disputes is actually a very important of the aspect of the mediation process. Okay. So this is the legal framework within which I think we are working on insofar as the development of an online dispute resolution system is concerned. And as you will appreciate, what I wanted to highlight is the peculiarity or the specific nuance under Philippine law between or the distinction between commercial ADR and administrative ADR. And I wanted to just discuss some of the points of comparison for these two kinds of ADR. So for example, in terms of party autonomy, usually party autonomy is expressed in the ability of the parties to agree to the ADR methodology. Are the parties free to choose or not to choose to submit their dispute to ADR? If the parties can freely submit or refuse to submit their dispute to ADR, then that's commercial ADR. So it's a product of an agreement between the parties. If the parties are compelled or mandated to submit their dispute to ADR, then that will be more of an administrative ADR. So it's not commercial ADR. Okay, so it will not be ADR under RA 9285, but an ADR under perhaps the regulations of the particular agency. In terms of the neutral, what's the difference? For commercial ADR, the neutral would be a private individual. In administrative ADR, the neutral would be a public official. Okay, so for example, the mediation and the adjudication before the DTI, that would be an administrative ADR. Mediation, adjudication before the IPO also would be considered administrative ADR. Insofar as power to appoint neutrals, in commercial ADR, normally it's the parties who choose. And normally they can choose from anyone. They can choose anyone as their neutral, as a rule. In administrative ADR, normally it's the government, the rules of the agency that determines who will be the neutral that will help the parties in resolving their disputes. Now, jurisdiction, this is related to the first item. If the jurisdiction of the neutral is based on agreement, so for example, if the parties agreed that their disputes will be resolved by mediation, ADR, arbitration, then that is commercial ADR. If it's law-based or provided by the rules or by the law, then that's administrative ADR. In terms of administering institution, if it's commercial, we normally have private ADR institutions, like as mentioned, PICCR, PDRC. If it's administrative, it's normally the government agency involved that resolves or that helps the parties with their disputes. Now, this is a very important distinction. Is it in lieu of litigation? And when I say litigation, normally trial court or administrative litigation. The idea behind commercial ADR, particularly commercial arbitration, is it replaces the court, the trial court process. So if you choose arbitration in your contract, then the other party cannot drag you to court to the trial court, cannot file a complaint in the trial court. After the arbitration, your remedy will be most likely enforcement of the award or setting aside of the award and then appeal. But you cannot go to court in lieu of the arbitration clause in your contract. Whereas in administrative ADR, normally it's just a precondition to going to further litigation process. So if, for example, the dispute is not resolved at the admin level, then as we all know, we can go to the office of the president and then to the courts afterwards. So it's not in lieu, but it's normally a precondition to further litigation. In terms of the rules that are applicable, if it's commercial ADR, normally it's the special ADR rules. If it's administrative, then it's either the rules of court, whether applied directly or suppletorily, and the rules of the particular agency. Okay. Appeal. If it's commercial ADR, generally no appeal. If it's administrative ADR, generally you can pursue appeals. Okay, so just a snapshot of the distinction between commercial ADR and administrative ADR. Now, why did I highlight this distinction? Because I think it will be helpful to take this into account in developing an effective PODRS. And why do I say that? Okay, so for example, in developing a PODRS, what kind of ADR system are we envisioning? Is it commercial ODR? Is it administrative ODR? Or is it a combination of both? I would think that combining both would really be helpful in ensuring that disputes are resolved efficiently. Okay, so for example, if the PODRS will allow the parties to first choose whether they prefer commercial ODR, and then if that fails, that's the only time that they will go to administrative ODR. It might result to some delays, but if the system is efficient, I think that will be helpful. Like for example, when we are administering arbitrations in the PICCR, what normally takes time is getting the parties to consent to the use of the rules of the PICCR. It takes a while because there are lots of correspondence back and forth. But if you do it online, like when someone files a complaint, and then it's automatically, the system automatically asks the parties, are you willing to, for example, have your dispute resolved through commercial mediation or arbitration? And if they say yes, automatically a mediator or arbitrator will be appointed. And if they say no, then automatically it will be routed to, for example, the DTI for handling. So I think that's one way of combining both commercial and administrative ODR. And then the second point, sorry, Craig, just a couple more minutes. The second point is maybe it will also be important to include enforcement of the decisions as an important objective of the PODRS. Because in my experience, one of the difficulties with ADR in the Philippines is really enforcement. Even if, for example, the mediation process or the arbitration process takes 6 months to less than a year, the enforcement takes so much time. It can even last several years because again, the clogged court dockets. So if there is a system of enforcement that would that can be made part of the PODRS, I think that will be really helpful. I believe in other jurisdictions, and maybe Craig can speak to this later on. In some jurisdictions, they have mechanisms to immediately implement the decisions of the mediator or the arbitrator. Like for example, I think chargebacks, although I'm not really sure how that works, or maybe refund or return of the items. Those are things that can be automated and can be made part of the PODRS. Then third, consider the potential role of the ODRS of the online platforms. I think we're all familiar with how eBay, for example, developed its own dispute resolution system online, and the ODRS of these platforms, I think, can complement the efforts of the DTI to minimize the disputes that are escalated to the DTI or to the courts. So if they can be resolved initially by the parties or secondarily with the assistance of the online platforms, then there's no need for them to be escalated to the DTI or even to the courts later on. Okay. And then finally, maybe consider the role of ADR institutions. Like for example, if parties or if the DTI would need, because as I understand it, there are so many online disputes that are being filed now, especially beginning the pandemic. And there might be a need to build capability or at least resources in resolving or assisting in the resolution of those disputes. And the various ADR institutions would have like pool of mediators or arbitrators that can help in making recommendations, for example, to the DTI on who can be appointed for these tasks. These ADR institutions can also help in training potential mediators and arbitrators who can assist claimants and respondents in resolving their disputes. So I think this is something that can be integrated as part of the PODRS. And some jurisdictions, I believe, have this option upon filing of the complaint. If they are asked, would you like to have this submitted to commercial mediation, then that will be referred to a commercial mediation center. And then thereafter, if the decision is to be, the settlement agreement is to be enforced or implemented, then that's when the DTI may perhaps come back in to help the parties implement the settlement agreement. So I'm sorry I exceeded my time. My sincere apologies, but those are all that I wanted to highlight for from the national perspective.
Thank you, Attorney Calimon. So we have listened to the national perspective of the online dispute resolution. Maraming salamat, sir. For your questions, I'm sure you have some or any clarification. You can send them here in our chat box, or you can use the Q&A function at the bottom of your screens. Or later, you can also have an opportunity to ask your own question to our presenters. Right, for our next presentation, we will be listening to the online dispute resolution and international regional perspective. Our speaker received a Bachelor of Arts from New College in Sarasota, Florida, and a Juris Doctor from the University of Pennsylvania Law School. His law course of study included classes in administrative law, regulated industries, international law, and antitrust law. He is founder and managing member of the Alliance Law Group, USA. His legal practice focuses on telecommunications, internet such as e-commerce, e-government, cybersecurity, etc., and intellectual property law such as creation, protection, licensing, enforcement, and compliance with international standards in the US and internationally. Our speaker's practice has a strong international component. His work internationally has involved policy-level consulting for both governmental agencies and NGOs on a broad range of issues concerning telecommunications reform, liberalization and privatization, intellectual property rights enforcement and compliance, internet, cybersecurity, e-commerce and e-government, compliance and conformity with international standards and best practices, the relationship of these issues to economic development, and recommendations for and crafting of new laws or amendments to existing laws, as well as presentation of commercial clients. Ladies and gentlemen, let us all welcome Attorney Craig Blakely. You have the virtual floor, sir.
Thank you very much. I really appreciate that very kind introduction. Thank you also to the members of the Respond team. Thank you to USAID. Thank you, of course, to our colleagues at DTI. Thank you particularly to ASEAN and to Don for their very interesting and informative comments. I hope that I can do them justice by providing some additional perspective from an international front. If you could display the first slide, please. As I said, I will be talking about an international perspective in ODR. I think you will see my point is really going to be that there are many different threads going forward in terms of international ODR, but I think you will be able to see as I talk that what the Philippines is contemplating is very much in line with international best practices and with the international trend, the growing international trend to implement online dispute resolution. If I could have the next slide, please. This just briefly summarizes a little bit of my background, the Pro-ICT project that I'm working with in the Philippines. I'm going to skip over this, but you're welcome to look at it at your leisure. I'm sure that the Respond team will make copies of this program available if you wish. Next slide, please. in talking about my presentation, I'm first going to touch very quickly on the purpose and use of ODR, and particularly its origination with ADR. I'm going to compare ODR versus ADR. I'm going to talk a little bit about the use of ODR in e-commerce. Part of the effort that's taking place in the Philippines to put an online dispute resolution mechanism in place, it's something that's called for in the Internet Transactions Act, which is now pending in Congress. And I think the idea is that ODR, at least in an e-commerce context, will help enhance the trust and comfort level of consumers in using e-commerce. I'm going to talk a little bit about court-related ODR, because just as ASIC, Anne, and Don talked about the use of ADR basically to avoid going to court, interestingly enough, courts are increasingly using ODR themselves. I'm going to talk a little bit about international standards, the UNCITRAL technical notes on ODR, and a couple other ODR standards. Then I'm going to touch base on ODR in the United States, in Canada, in the EU, in ICANN, in China and Korea. And then I'm going to sum up with my summary conclusions. So that's a quick overview of what I intend to cover today. So let's go to the next slide, please. As Don and ASIC Ann both said, ODR really had its origins in alternative dispute resolution, conventional ADR, which is very much a face-to-face kind of process intended to, in effect, replace courtroom litigation, to reduce the cost, the expense of having lawyers, the expense of litigation, to make it, in effect, to provide a dispute resolution mechanism that's quicker, cheaper, and more accessible than traditional courtroom litigation. Mediation, as has been discussed, is a voluntary process. The strength is it's voluntary. The parties can shape the resolution of the issues, usually with the help of a neutral third party, as Don mentioned. The disadvantage is the same as the advantage. It's completely voluntary. It can't be used if either party refuses to participate. Arbitration is technically voluntary, but actually it's been used contractually, particularly in the United States, by the side with the greater economic power, such as employers, online e-commerce platforms, et cetera. Essentially, it's an adversarial system, a kind of simplified trial presided over by one or more arbitrators. Evidence is presented. And typically, unlike a mediation where both parties kind of compromise, typically arbitration results in a winner and loser, and it's enforceable in court. Now, one interesting thing about arbitration that I wanted to mention, which I think is very interesting. For many years, arbitration has been preferred by e-commerce providers in the United States, particularly big e-commerce platforms like Amazon. And their terms and conditions mandate that if you buy from them, you have to agree to arbitration. Well, what happened earlier this year is very interesting. Amazon was confronted with claims of about 75,000 people who complained that they were being recorded by the Amazon ecosystem without their permission. So they filed lots of lawsuits, or rather lots of arbitrations. And under arbitration rules and under the rules that Amazon had adopted, Amazon agreed to pay all or part of the filing fees, the arbitration filing fees in this case. Well, guess what? Amazon went to court and went to a judge and said, you know, this is too expensive. You got to let us out of arbitration. And the judge said, guess what? You chose that. It's your problem. So Amazon now, interestingly enough, has moved from arbitration to letting people sue them in court because they decided it was less expensive. So I thought that was very interesting. And it indicates that sometimes arbitration can actually backfire on those who are requiring it. And sometimes litigation in certain circumstances may end up being preferable. Next slide, please. There are other ADR methods other than arbitration and mediation, which I just wanted to touch upon. One is called facilitation, which assumes that if parties want to reach a settlement, a neutral third party can help them do that. There's something called neutral evaluation, which is a situation where you have a neutral party who's an expert in some kind of field. It's best suited to cases involving technical issues, and then simply negotiation, which is, it isn't commonly thought of as an ADR process, but it always exists. Parties can sit down face-to-face through lawyers or directly and try and resolve the issues. And this can happen really at any stage of the various ADR processes that we've talked about. or any stage really of litigation. Next slide, please. ODR versus ADR. ADR, alternative dispute resolution, is traditionally a face-to-face interaction, which actually relied on the fact that it is face-to-face to let parties come to some kind of an agreement or resolution. ODR, as Don said, is based on sort of ICT technology, primarily the internet. Physical face-to-face interaction isn't necessary, but importantly, internet connectivity and a device for accessing the internet are. So sometimes if you got people without strong internet access, if you got folks that really don't have a device to access the internet, it may not be suitable, it may not be accessible to those people in terms of online dispute resolution. But one of the benefits of ODR is it can take place over long distances. It can take place between people in different cities, in different countries, even on different continents. That's one of the benefits of ODR. Next slide, please. E-commerce is one of the important areas where ODR is very useful. And as I said, one of the motivating factors, I think, behind DTI's implementation of the Philippine ODR system, and one of the reasons that the Internet Transactions Act calls for that, is because it really is very useful in developing consumer trust and confidence in the e-commerce system. E-commerce purchases can be made from any internet-connected device. They're instantaneous, and they can be made without regard to the physical location of the buyer or the seller. Well, dispute resolution, unless it's provided somehow by law, typically is governed by a website's terms and conditions. And as I said, they also sometimes provide e-commerce merchants and retailers often provide a system of resolution that's favorable to them. At the same time, though, if you put in ODR resolution mechanisms, it provides consumers with a resolution mechanism that's similar to what they get using e-commerce. It can be done very quickly, at low cost, much more quickly than a court proceeding, and it's accessible to them wherever they are. They don't have to go to court. They can be in their home. They can be in their office. They can use ODR to help resolve e-commerce transactions or disputes. Next slide, please. So as I just said, e-commerce customers, they want a process for resolution that's akin to what they used in buying the product or buying the service. They want something that's easy, relatively straightforward, not complex, inexpensive, that makes sense from a cost-benefit perspective. Many things that are purchased on the internet in e-commerce transactions are relatively low cost. If you're spending $50 or $100 on something, it doesn't make sense to go to court to lose wages if you're a salary person who's working on an hourly basis. You don't want to lose a day's pay or half a day's pay. You don't want to have to travel and go to court and waste that time. But if you can do it over the internet, you can do it on an ODR perspective. It makes sense from a cost-benefit perspective, and therefore it's more convenient and relatively quick. And it also benefits, interestingly enough, it also benefits e-commerce providers, e-commerce retailers, e-commerce platforms. And why? Because consumers are more confident that if they have a problem, they can get it resolved, that there's a mechanism by which they can get it resolved easily, quickly, and inexpensively. So it enhances consumer confidence in using an e-commerce system, which is very important. Next slide, please. Even though there are obvious commercial applications for ODR, there are also, interestingly enough, judicial applications, court-related applications for online dispute resolution. There's a definition at the top of this slide. Court-related ODR is a public-facing digital space in which parties can convene to resolve their dispute or case. And we point out some differences between ODR in a courtroom context or in a court context and in a regular commercial context. It usually doesn't require the filing of a formal complaint. It supports settlement negotiations. It supports mediation. If parties can resolve the dispute, rather, the system often generates a settlement document that can be used and that can be filed with the court. If they can't resolve it, forms that are necessary for filing a formal legal action can be generated. It functions as Don was describing. You have sort of ICT type technology that functions as a kind of gatekeeper that decides what type of case it is, what type of ADR mechanism is important to be used, and then steers the parties in that direction. So interestingly enough, even though ADR and ODR are offered often as alternatives to court-related litigation, I find it very interesting that courts increasingly, particularly for small cases, for small claims involving relatively low amounts of money, courts are moving increasingly to implement and utilize ODR systems themselves, finding that it enhances people's access to the court system, it enhances trust in the court system, and it enhances the usability of the court system, particularly if it can be done without a judge's participation, and it tries to do some of the unclogging of court systems that have been discussed in previous presentations today. So it's a very interesting sort of turn of events that courts themselves would be using ODR. Next slide, please. I wanted to touch a little bit on some international standards, and really Don and ASEAN have done a good job really of talking about the relevant international standards as they've applied to a Philippine context, and really the factors that they've identified you will see echoed in many ways in these standards. The UNCITRAL organization, the UN Commission on International Trade Law, has developed a variety of model laws over the years. They have a model law on e-commerce, they have a model law on e-signatures, they have a model law on transferable electronic records. They do not have a model law on online dispute resolution, but they do have some technical notes that are useful. You can see sort of a description of the process that often the ODR process involves a multi-stage process that begins with an electronic submission of a claim. Then there could be triggered a process of negotiation, often accompanied by some active involvement of a neutral third party who tries to guide this discussion toward a successful resolution. And then if there is not a successful resolution on a voluntary basis, many systems then provide for a binding decision by the neutral third party. Doesn't have to be that way, and we'll see through my discussion that there are many alternate ways of implementing ODR, but that's at least one way, one direction to go. Next slide, please. As you can see, the international standards that were developed by the Advisory Committee of the National Center for Technology and Dispute, they have a lot of the same factors that have been identified by ASEAN and by Don. Accessible, ODR systems should be accessible. They should be easy to find and accessible. They should be available in a variety of languages so that people can speak the language of the area that they're working in. They should be affordable, because if you're going to have an expensive ODR process, it's not an effective substitute for courtroom litigation. Has to be transparent. People have to understand exactly what the dispute resolution process is that they're using. They have to know who the decision maker is going to be. They have to be assured of security, that their data, the confidential data that they share, is not going to be spread all over the internet. Now you have to know where they're located. Are they here? Are they in the Philippines? Are they in Manila? Are they in Virginia, as I am right now? They have to operate fairly. The neutral they have to be assured that the neutral third party really is neutral. And the algorithms that are involved in the software have to be designed in such a way as to not give any systematic benefit to one party or the other. And they should be innovative. And I will talk at the end of my presentation about the possibility of some innovative types of ODR. Next slide, please. This is a little bit of the same thing as the previous slide, but it's a little bit more refined, more current. The top factor, accessibility. A lot of folks have their only internet access is through a mobile device, a smartphone. So when you're talking about ODR and you want to make it accessible, it has to be accessible in terms of language, in terms of geography, but ideally accessible also through a smartphone. because that's the way a lot of people communicate with the internet. That's the way a lot of people use. And if it isn't suitable for mobile use, it's probably not as accessible as it ought to be. It has to be accountable to the institution's legal framework and communities. It has to be competent. They have to have the relevant expertise. They don't need to be a lawyer, as Don, I think, mentioned. They don't need to be a lawyer, but they have to be competent. They have to have the relevant expertise. They have to speak the language. They have to know the culture. That's the kind of competence we're talking about. Have to be confidential. The information have to be confidential. They have to be impartial. They have to abide by and uphold the laws in the relevant jurisdictions in which they operate. And importantly, secure and once again, transparent. If it's going to be a process that people use, they have to know how the processes work. They can't just be a black box. They have to know it. They have to understand it. They have to have confidence in it, that it's reliable and that it's going to render a fair decision. Next slide, please. I wanted to talk a little bit about ODR in the US. In the US, there's a national law that favors arbitration. But a lot of companies have found it in their interest to use their own ODR process. Don mentioned eBay, pretty well known. At one point, I don't know what it is now, but they were resolving 60 million disputes a year through their own dispute resolution process. That's more than the US court system resolves. What they do now is they outsource. If you go to eBay, you will find that they outsource dispute resolution to a company called Square Trade. Company files an online complaint. Square Trade tries to resolve it using a web-based process. And if that is unsuccessful, they bring in a professional mediator. You pay $15 a day. eBay subsidizes the rest of that. And what they have found, interestingly enough, is that consumers are more interested in getting a quick decision. They've got to have some confidence that the decision is right, but they're more interested in a quick decision if they can get their complaint heard and resolved. So in the US, commercial ODR is a lot of what goes on in this country, whether it's through mandated arbitration or online dispute resolution at large eBay or e-commerce companies like eBay. Next slide, please. As I mentioned, there's increasing use in the United States of ODR systems by courts. And the reason for that is they want to address issues, they want to decrease barriers to people using courts. What are those barriers? Time and inconvenience. I, as a lawyer, make arguments before courts. And because of the pandemic in the United States, number of arguments that I've done recently have not been in person at court. They've been in my office or they've been in my home using an internet and a virtual argument. What's the good of that for me? It saves me having to go to court, take an hour out of my time, for which I would charge my client, to go to court, make the argument, and come back. For people who don't have lawyers, it reduces the intimidation factor of an in-person court. If you don't know your way around a court, you're intimidated. You don't know what to do. And the confusing nature of civil procedure as a non-lawyer, if you have an ODR system associated with the court, a lot of these problems are overcome. Now, the American Bar Association did a study. They released the report in 2020. It studied 2019 use of ODR by courts in the United States. At the end of 2019, and I'm sure it's increased dramatically since then, there were 66 active court-annexed ODR operations in 12 states. 16 ODR sites were added to courts in 2018, 31 in 2019. So you can see it increased tremendously year by year. And although I don't have a current report, I'm confident that it's increased dramatically since then. Now, these aren't big multi-million-dollar cases that we're talking about that they hear, but it's things like traffic, parking, small claims, family law, landlord-tenant items. But those take up a lot of time for a court. And those are the kinds of things that an ODR system can deal with, can help people without a lawyer try and resolve amicably and without necessarily the involvement of the court or a judge. Next slide, please. In Canada, in British Columbia, they've used the same kind of thing. They have something called the Civil Resolution Tribunal, which they launched in 2016. And what happens on that is they use a kind of technological gatekeeper to screen complaints. You start out with something called the Solution Explorer, which asks a series of questions and lets you figure out whether your case is appropriate for resolution at the CRT. And then they provide access to a confidential negotiation platform if it is appropriate. If you don't succeed in the negotiation, a case manager will try to facilitate an agreement. And if that's not successful, then a CRT member will make a binding decision about dispute, which can be enforced in a court. So this is, again, is another example of one of the Canadian provinces moving to a situation where the court actually uses ODR in a very active fashion. Next slide, please. Now, ODR in the EU, in the European Union, is a kind of different animal. The EU has its own online dispute resolution platform, and an e-commerce retailer or platform provider is obligated to provide a link in their site to the online platform. And if there is a complaint, if a consumer has a complaint, there's a process by which you file a complaint with the ODR. It's referred to an approved dispute resolution party or body rather, and there are certain time limits that apply in terms of when this can be resolved. So it is something that is mandated by which the online retailers and e-commerce providers have to inform consumers that it's available. Next slide, please. The Internet Corporation for Assigned Names and Numbers, most people know it by ICANN. They have their own online dispute resolution process for resolution of disputes involving domain names. It's a little bit more formal. It involves online presentation of evidence to an arbitrator and one person or a three-person panel. Because of sometimes the stakes involved, as I said, it is more formal, but it is online, and it is sort of one end of the spectrum of the ODR process, which goes toward the more formal process. And one of the goals that I have as I go through this is to show you the range of possible ODR solutions that there are. There's no one size fits all, but what the Philippines are proposing, what the process that's underway in terms of DTI and the Respond folks who are working with them, it's very much in line with international best practice. But there is no one size fits all. It has to be done, I think, in a flexible fashion and can be done in a variety of ways. And that's my message to you, that it can be done governmentally, can be done private sector. Ideally, it's a blend of the two that offers a flexible solution for those who can comfortably or can use it and who can need it. And it provides a resolution mechanism for those who wouldn't otherwise be able to go to court. And it increases that trust factor that's so very important in having an effective e-commerce environment. Next slide, please. All right, so ODR in China. I picked something which I thought was interesting because it's so well known. But just like eBay has its own dispute resolution system, so does Alibaba. And it provides on its website definitions of what's a severe dispute and what's a general dispute. You can see some of the examples here. An example of a severe dispute is I make a payment and I didn't get anything. Severe dispute. I order a mobile phone and I receive a t-shirt. That's from the Alibaba site. That's the kind of severe dispute. A general dispute would be some problem relating to the length of the warranty. I got a damaged product. There were unresolved problems dealing with the size, color, texture of the product. Next slide, please. Alibaba has different kinds of penalties for those sorts of disputes. In a severe dispute case, this is from the Alibaba site, after considering the evidence, Alibaba may terminate and blacklist the guilty supplier's account. Well, for a merchant that depends on the Alibaba platform to sell products or services, that's the kiss of death. So that's a very severe penalty. So you've got to be, I would think that people who sell on that platform got to be very careful that they live up to the promises that they made to their consumers. In general dispute cases, they can publish the complaint case record on the defendant's site on Alibaba for 90 days. And that, of course, has its own negative impact because people will read about that. It's like a negative report on eBay where somebody files a negative report about a particular seller or buyer. Next slide, please. Korea. This is another example of a different sort of approach. Korea has something called the E-commerce Mediation Committee, which is entirely voluntary. It's a mediation process. Unlike the EDU, however, online retailers don't have to tell their customers that it exists. You've got to know about it, but they don't have to tell you that it exists. And there's no requirement that they participate. So it's totally voluntary. It's a mediation process. But if neither party objects and the mediation committee actually issues a proposed decision, and you don't object within 15 days, then it becomes binding. But there are a lot of hurdles to get it to be binding, and it really is just a mediation process, as the name for the committee says. Next slide. So, just to sum up, the use and implementation of online dispute resolution platforms is increasing dramatically worldwide, commercially, governmentally, and by courts. Everybody is using ODR. There are a variety of different sorts of ways of using it. ODR extends the geographic reach of traditional ADR systems. But even those kinds of systems, though, are very centralized. And the very nature of the internet is that it's decentralized. Remember, packet technology was designed initially to use a variety of mechanisms to get to you. There's no one route. The packets come in from a variety of ways. They get to the end user and put together what you see on the screen. But it goes in a variety of different directions. It's decentralized. So one of the interesting developments that I think can happen, will happen with ODR, is that it makes it possible not just to perform the kind of gatekeeper function that Don was talking about, but it's going to make it possible to consider technical innovations that go well beyond traditional ADR. For example, the suggestion has been made to use blockchain technology. It's the same technology that makes cyber currencies possible, to use that technology to provide a crowdsourced jury to resolve disputes. Very interesting and challenging concept. And I'm confident that as ODR becomes more used, there will be more and more of these technologically innovative solutions that are developed. At any rate, that's the end of my slide. If you can put my thank you slide up, I'd appreciate it. Thank you for your time. I hope that I've contributed somewhat to the conversation today.
Thank you very much. Thank you, Attorney Blakely. We appreciate very much the examples that you presented to us. So everybody, we were able to listen to the international and regional perspectives on online dispute resolution. The UPAF Respond team has prepared a video on the Philippine online dispute resolution system. Let's watch this.
The Philippine Online Dispute Resolution System, or the PODRS, is envisioned to be a web-based portal where clients may log their complaints and seek relief for a product or service that was availed online or offline. Filing of complaints is now made easy through the self-service portal of the PODRS. Consumers are now empowered to log their own complaints. To file a complaint, the user may simply click on the File a Complaint link found in the DTI website. Upon doing so, the user will be asked to log in using their registered email address or cell phone number. If the user is not yet registered, they will be asked to first provide their personal information before they can proceed to filing a complaint. But if the complainant already has a registered account, the system will be able to automatically populate the complainant's information based on registration details. Next step, the user will have to encode the complaint details and respondent details. Once done, the user will review the details of their complaint, submit it, and take the oath of undertaking. The system will then issue a complaint ticket number, which the user may use to monitor updates on their submitted complaint. After this, the system will then automatically validate the concern, and based on the information encoded by the complainant, it automatically routes the concern to the appropriate group. For example, if the user selects manufactured products as the subject of complaint, the nature of complaint as deceptive, unfair, or unconscionable sales act or practices, and the transaction type as purchase, the concern or complaint ticket will be automatically routed to the DTI work list. The receiving group will then assess and resolve the concern using this work list feature. If the concern cannot be resolved after mediation, the complainant may use the same ticket to escalate the complaint to adjudication, and in some cases, if needed, log an appeal using the same complaint ticket. With the PODRS document management feature, issuing notices of adjudication and mediation can be as easy as loading the form in the screen and affixing the processor's digital signature. Commonly used forms will now be pre-configured in the system to save time and resources on printing and uploading scanned copies. And in addition to that, authorized users may also use templates to configure customer feedback forms and spiels for notifications and alerts. Users will also have an option to subscribe to notifications and alerts to receive updates on their filed complaints or important events via email or SMS. On the other hand, concerns which are outside the jurisdiction of the DTI may now be automatically endorsed via email to the appropriate agency. For example, if the complainant tags the following during complaint filing: subject of complaint as life and non-life insurance claim, nature of complaint as deceptive, unfair, or unconscionable sales act or practices, and the transaction type as purchase, upon its submission, the system will generate an email endorsement to the appropriate agency to handle the complaint ticket. The PODRS is also equipped with the following features: a dashboard which provides easy access to key statistics for each type of user, a featured explainer video, social media links, frequently asked questions, news and advisories, and an account management facility that allows users to update their personal and account information and manage their notifications and alert preferences. And those are just the Phase 1 features of the Philippine Online Dispute Resolution System, or the PODRS. Additional features will be introduced for access upon full development of the system.
Thank you, Upa Fresponti, for our video on the Philippine Online Dispute Resolution System. We have a question here. If we are providing copies of the presentations, we will request first permission from our speakers if we can do so. All right. And anyway, we have our group chat. We will be distributing them once we have the permission. Okay, so we are now about to start our open forum for this morning's activity. But before that, let's have a 5-minute break. It's already 11:02. I'll see you back in 11:07. See you. All right. Welcome back, everybody, to the forum on online dispute resolution system. So we are now in the third part of our forum this morning, which is the open forum. I would like to invite, of course, to be in spotlight, our presenters for this morning. We have, of course, Attorney Craig Blakely on the online dispute resolution on international regional perspective. We also have Attorney Donmar Kalimon on online dispute resolution and national perspective. And for the overview of the Philippine online dispute resolution system, I'd like to call on, of course, the reliable Assistant Secretary of the DTI Consumer Protection Group, Sir Ronel Abrenica. So Isabel, kindly provide them the spotlight for our open forum. So for our participants, you may have three options to put forward your query or your clarification. You may send them in our Q&A function or through the chat box here, or you can easily raise your hand and we will call you to direct your query or your comment to our presenters. Okay, I have received quite a lot of clarifications. No? All right, let me just get them. Okay, for the first query. Okay, hold on. We don't have yet ASEC Ronel in the spotlight. There, okay. So for our question, due to the emergence of e-commerce or online shopping, there can be instances where consumer complaints can be cross-border. A seller is from another country. So how can the PODRS cater such complaints, since sometimes the sellers are not registered here in the Philippines, which at times provide difficulty in, of course, resolving the concern? Anybody can put in their input, Attorney Kalimon or ASEC Ronel, and of course, Attorney Blakely.
I can give some thoughts, Ms. Camille, if that's
yes.
okay. Okay, I think that's also one of the, I guess, the reasons why I believe we should consider the distinction between commercial and administrative OADR in the PODRS. Because under Philippine law, through commercial ADR, for example, commercial arbitration, the process can lead to a commercial arbitration award that can be enforced anywhere or more easily anywhere in the world. So that's one of the key advantages of arbitration over court litigation. While, of course, court decisions can be enforced outside of the Philippines, the process is more tedious. In fact, in the Philippines, it requires full-blown trial to enforce foreign judgments in the Philippines. So if we are using commercial arbitration, it tends to be more easily enforceable. Not all the time, of course. When it comes to mediation, on the other hand, there's also a quicker process to enforce mediated settlement agreements under RA 9285. In fact, if you have a mediated settlement agreement under 9285, you just deposit it with the regional trial court. And if there's a breach of that agreement, you can ask for execution of that mediated settlement agreement. No need to file for civil action for specific performance. So that's one of the advantages of a commercially mediated agreement. So that's, I think, one of the advantages of using commercial ADR in a PODRS to address multi-jurisdictional or cross-border transactions. Maybe Craig can also give his thoughts.
Well, thank you, Don. One of the comments I wanted to make is it seems to me there's an interrelationship between the operation of the online dispute resolution system and the Internet Transactions Act. I mean, the online dispute resolution system is really called for by the Internet Transactions Act, which I think has passed the House, but is still pending in the Senate. And one of the issues there, which has become fairly controversial, is the issue of extraterritorial jurisdiction. And, you know, there are requirements that Internet businesses register, but there's also this idea that I'm trying to recall the language of the bill, but it's something to the effect of if you purposely avail yourself of the Philippine market, particularly judged by the amount of consumer goods or products or services that you provide in the Philippine market, that you will be deemed to have subjected yourself to the authority of the Philippine authorities, and I guess particularly the e-commerce bureau that's contemplated in DTI. So it seems to me that at least part of the answer to this may lie in terms of what Don just said. I think that's very practical and worthwhile advice, but it may also have some relevance in terms of what the ultimate decision is on the ITA, the Internet Transactions Act, and the kind of provisions that are made with respect to extraterritorial jurisdiction, because it could be, for example, that if there is a provision which is something to the effect that I remember, that even if you're not registered, if you're outside of the Philippines, but you purposely avail yourself of the Philippine market, that you will be deemed to be subject to its jurisdiction, which would include, I would think, being subject to the online dispute resolution system. Anyway, that's just a thought.
Thank you, Attorney Blakely and Attorney Calimon. Asipranel, do you have anything to add on that? Asep? Let us proceed to the next question. How would the PODRS comply with the due process requirements of sending notices and copies of decisions to the parties, knowing that in the Philippines, we are all aware that we have the ADR still in implementation? Attorney Calimon?
Oh, okay. Well, I based on what I've seen from the reports on the PODRS, I think the process contemplated can easily comply with the due process requirement. I think, of course, I think this contemplates that the user or the consumer will agree to receiving notifications by email or some other electronic means. And I think the respondent as well, and maybe with the help of the online platforms in entering into certain transactions, may be required to agree to a system by which notifications will be received online. If not, then I think email notifications can also be availed of. Under the ADR Act, I think notifications by emails or by electronic means is also contemplated. In fact, even our court system now has sort of eased on the notification requirements, such that filing by email or service by email is already starting to be acceptable.
All right. Thank you, Attorney Calimon. How about Attorney Blakely? How was the transitioning in your country from ADR to ODR regarding the decisions?
Well, I think the notification, the due process requirements are certainly here as well. And I think that the notifications are usually by email or some kind of online notification. Typically, when you would agree to do that, you would agree to accept notification by email or some kind of online notification. And as Don said, you know, as a lawyer, when I file a document in court, I now have to provide not only my phone and fax number, but I have to provide my email address. And often court notifications in terms of scheduling conferences, including various types of hearings, if there's been a decision, You know, I've received a notice only recently from a court, and the decision was given to me by email along with in effect, the text of the decision. So I think the issue of due process is important. I think also there's a related question, which I think is important, which is accessibility. In designing the Philippine online dispute resolution system, particularly since so many people in the Philippines depend on smartphone access to use the internet, I would hope that the system is designed, you know, along the lines of one of the international standards that I mentioned, that it's being designed to be mobile friendly, or at least iPad or tablet friendly, because a lot of people don't necessarily have a full-size desktop to use. So I think they have to be specifically designed. And it's not exactly a due process argument, but it's close because it's an accessibility and usability argument. So it really depends. Hopefully the system will be designed to be utilized, not just using a full size like a laptop or something, but will be accessible, will be accessible using a mobile phone or a tablet.
All right. Thank you, Attorney Blakey. We take note of those things. All right, we have received questions in our Q&A function. What can be the process by which the DTI or other agencies with consumer protection programs using ODRS filter nuisance complaints? Attorney Kaliman?
I think on this one, I might defer to Craig. I actually have no experience on that, but I do have read somewhere that these ODRs would have like an algorithm that can determine. I don't know how. Perhaps the system developers would have a way to maybe, for one, if the email address or the source of that of that complaint is a dubious email address, for example, maybe there's a way to filter those type of complaints. I don't know, Craig, do you have anything to add there?
As, you know, I got so accustomed to you going first, Don. I don't know what to say. But I think you're right. I mean, there would have to be some kind of algorithm. Perhaps there could be, you know, some kind of, you know, it's not uncommon these days, you know, when you're banking or doing some other things, to have a two-step verification, you know, an email address and a phone number, something like that. I mean, it's possible, although I will tell you, just as a matter of personal experience, I had a very strange identity theft problem a couple of years ago. Somebody set up a bank account in my name in Indiana. And the woman at Indiana found my name online, saw that I was a lawyer in Virginia, and called me and said, "Did you set up an account?" And I didn't. And the whole idea of these fraudsters was they were going to set up an account and pass fraudulent checks through this account and be paid. And then I would be left holding the bag. Well, what they did is, she said they actually called a person who identified themselves as Craig Blakely. So in addition to setting up a fraudulent bank account, they set up a fraudulent phone number so that so that when somebody called, they could actually say that they were me, you know, use my name. So there's nothing that is completely, you know, absolutely bulletproof. But I think, as Don said, some kind of algorithm that smarter people than us two lawyers could put together, or some kind of two-step verification that tries to verify or confirm the identity of that person. But there's probably going to be nothing that can absolutely make it bulletproof.
Thank you, Attorney Blakely. Okay, let us see if Asek Ranel can already join us, because I know that he's in another meeting. Asek Ranel? Okay, so let's go to another question from our Q&A function. Is there a 3-7-20 time frame for the processes involved in the PODRS? The 3-7-20 time frame, that's from our ARTA. It's the number of days that we should be answering to queries, complaints from entities or individuals to the government offices. The 3 days, 7 days, and 20 days, depending on severity, you know, of the query or the request or the question. I was hoping that ASEC will be answering to this regarding the PODRS, sir. If not, I can. All right. Yes, we are considering this time frame. In fact, the UPAF Respond is also a partner of ARTA in making sure that the government offices comply, no, with this time frame in responding to queries, sorry, questions and clarifications from our consumers. Okay, let's proceed to the next question.
Let me just say one comment there,
Yes,
which obviously I'm not nearly as familiar with the Philippine situation as you are, but based on the information that I read and that I've read, the speed of the response to the consumers is one of the most important things. You know, if they can be responded to quickly, even if the decision is sometimes wrong, speed is important. So if we're talking about enhancing consumer trust and confidence in the system, knowing that their complaint has been looked at and resolved, even if occasionally it's an incorrect resolution, the speed of the resolution, I think, is very important to engendering consumer trust. So I think that's a very important issue that you're wise to pay attention to.
Yes, I'm sure ASEC has some data on how the FTEB, no, and the Regional Operations Group have been attending to these complaints and queries. In fact, we have a rate of almost 99% in responding to these queries and questions. ASEC, are you with us now?
Sorry for that. I was just attending another meeting. Pasensya na. Going to the question, the 3720 time frame. Yes, we will have this 3720 time frame for all processes. In fact, this is one of the considerations that we're looking at now. And true, as earlier said by Camille, we have a around 99.5% resolution rate and in handling the complaints. And but the 3720 will be at the time that we receive the complaint, at the time that the last communications was given to the complainant or the respondent.
All right. Thank you, ASEC. Okay, I just received a clarification from Ms. Portia of the ROG, DTI ROG. I think the ARTA days is not for responding to complaints, but it's for resolution. Yes, ma'am. Resolution and responding, sir, ma'am, about the query or the complaints. Thank you. I'd like to go back to the filtering nuisance complaints. I think Sir Roy has something to say. Sir Roy?
Yeah, Ms. Camille, actually, it was already raised with the CPG Mancom before on how to, well, that was one of the concerns during our workshop. So basically, it was decided by the CPG Mancom that there's no wrong door policy and they don't want to turn down any complaints. So the thing is that DTI is very much considering all complaints and they don't want to leave anything behind. So of course, there could be some guidelines that could be formulated on how to use the system. But right now, the stand here is to accommodate all complaints and have it course to the correct process. Thank you.
Thank you, Sir Roy. I can see a raise of hand. I'd like to call on Miss Abigail Kalilong. Miss Abigail, you have the floor now. Please unmute yourself. Miss Abigail. Miss Abigail, can you hear us? You have to unmute yourself. None yet? Okay, while we're waiting for Miss Abigail, our next question would be, I would like to know the success factors in implementing an ODRS. Attorney Blakey?
Well, it depends on a couple of factors. I mean, you have to decide, it depends on whether it's a governmental ODR or a private sector ODR, and then you have to decide what the purpose is of it. But I think there are certain common factors that sort of transcend whether it's a government run system or a private run system. And we've touched on many of those. ASEAN and Don and I have all mentioned these factors, but it's worth reviewing them. One is it has to be accessible. You've got to have a system that is reasonably accessible to most people. And ideally, as I've said before, it's accessible via a smartphone and doesn't require a laptop or a full-size computer. It has to be transparent in the sense that the decision-making the process is open. The people who are involved, you know their background, you know their neutrality, it's guaranteed. It has to be publicized. You know, the difference between, for example, I was talking about the Korean, mediation committee, e-commerce mediation committee. That's a very different approach than the EU. The EU obligates retailers, online retailers, platform providers to provide a link to their online dispute resolution system. Korea doesn't. So, you may well purchase something in Korea and not really be aware of your rights. So publicity, I think, letting people know what their rights are available to them is, I think, important. And one of the things that could be considered, for example, with respect to the Philippine system, particularly with respect to e-commerce retailers, but perhaps brick and mortar stores as well, if that's part of its intended use, is to publicize it, to let people know. I mean, for example, if there was a requirement that for the Philippine online dispute resolution system, that an e-commerce retailer or platform provider had to provide information on their site about the rights that were available and how to utilize them, that would be an important point to ensure that it's usable, is publicizing it. So I would say transparency, accessibility, and publicity. There are many other factors, but those are certainly three of the top factors I would look at in trying to ensure that ODR is successful. And the other thing I would say is it has to be user-friendly. It has to have a website that's not complex. You don't want something that's extremely complex. Like I looked at the EU system. It's very simple. You file a complaint, you do this, you do that. You move from one stage to another. You have some kind of intake system which steers you in the right direction. If it's very complicated, nobody's going to use it. They're going to go online and say, I can't figure this out. This is too complicated. They're going to react to an online experience the same way that people react to a courtroom experience. Their eyes glaze over. They can get confused. They aren't going to try it a second time. So if it's publicized, if it's accessible, if it's transparent, and if it's user-friendly, the website has to be designed in a way that is user-friendly, that is, it's got to be something similar to what they see into an e-commerce platform. E-commerce providers, if they're successful, they make it very easy to find what you want and to buy it. An online dispute resolution system has to have those same qualities of ease of access, transparency, and consumer user friendliness. And if they do, and if it's well publicized, word of mouth will spread. Hey, I had some problem. I ordered a shirt, I got a phone, or I ordered a phone and I got a shirt. And guess what? I went online and golly, that was resolved really quickly. And I got what I needed. You get a few success stories like that, and it will be used enormously. It'll become viral. But on the other hand, if somebody comes on and says, I went online and I couldn't figure it out. It was so complicated. I had to go through 4 boxes just to sign my name. If it's that kind of thing, that will go viral too, and you won't have a usable system. So usability, consumer friendliness, transparency, accountability, and publicity, those are the factors I would look at.
We take note of that, Attorney Blakey. Any insights, Asa Cronel or Attorney Kaliman?
Actually, I just wanted to add from the perspective of someone who practices in the Philippines. Yeah. For me, we can say that an ODR system would be successful if we can, as much as possible, remove or automate as much of the process as possible. Because I think most of the processes in the Philippines are currently manual, except for sending emails or having video conferences. But I think the idea behind PODRS is really to automate as much of the process as possible, including the receipt and acknowledgement of the complaint. So it will really speed up the process, as well as maybe referral of that complaint to the appropriate department or to the appropriate next stage. So that's one. And then second would be acceptability. If it will be accepted by the users, then I think that's really one factor. That means it's really successful, because although I've been promoting ADR for the longest time as an ADR practitioner, it has not really been the popular mode of dispute resolution among Filipinos. If you count the number of commercial arbitrations in the Philippines since the ADR Act was passed in 2004, it's not too many. So while there are so many talks about arbitration being a preferred mode of dispute resolution, it's not really being used by the people. And hopefully, if the PODRS will actually be used by the consumers, then that's another measure of success. And then finally, enforcement. If you can enforce it, the settlement agreement or the award easily, then that's another measure of success. Because in court, as I said, it takes so long to enforce even the smallest arbitral award. So those 3, I think, are the success factors for a PODRS.
We also take note of that, Attorney Kariman. Okay, so suddenly we have a surge of questions here. So okay, let's proceed. Was there any instance that a party sued a mediator or adjudicator for reason that he or she was not satisfied with the result of the process? Sorry, Kaliman, did you have any experience with that?
In the Philippines, I'm not aware of any. There may have been situations where, although these are confidential, so it's mostly word of mouth. Instances where there were complaints about not a mediator, but I think an arbitrator, but not because they were not happy with simply because they were not happy with the process, but because there were some gross negligence or gross bad faith. Because as a rule, especially when it comes to commercial ADR, there's some level of immunity under Philippine law on the part of the ADR neutral. And you cannot be sued just because the parties were not happy with the decision. So it requires a higher level of negligence or bad faith. When it comes to administrative ADR, then we refer to the public officers law, the admin code, which has also been adopted by the ADR Act, IRR, insofar as commercial arbitral neutrals, or ADR neutrals are concerned. So again, there has to be some negligence or bad faith on the part of the neutral.
Thank you, sir. How about you, Attorney Blakey? Was there any instance that you can share with us?
Not in my experience. I mean, the issues about the appealability of arbitration awards, they're very limited in the United States in general. If you get an arbitration award, unless there's something, as Don was saying, just some kind of really gross negligence, it's generally not appealable. And ordinarily it would require some kind of extraordinary situation to bring some kind of legal action against an arbitrator or a mediator. I mean, you know, I could imagine circumstances where that would not be the case. I mean, if you had somebody who, for example, was trying to mediate a divorce and ended up, you know, having some kind of romantic involvement with one of the people in the divorce, in the marriage, I mean, that would certainly fall, I would think, under the kind of gross misconduct that Don was talking about. But failing that, those kinds of things, I'm sure they happen occasionally. I'm not personally familiar with a situation where they are, but then there's the issue of some kind of personal liability on the part of the mediator or the arbitrator. And then there's the question of whether their decisions are appealable. Of course, in a mediation is a kind of compromise. So that's really not, you know, appealable. An arbitral award in general is not appealable either, except for very specific and limited issues. So typically what happens when you get an arbitral award in the United States is you go to a court to enforce it, but the ability to appeal it is effectively very low. So, I mean, I'm sure it happens, but it's very rare, and they're what I would call them a one-off kind of situation, very rare. It sometimes happens. I'm not personally familiar with it.
Thank you, Attorney Blakely. Okay, to the next one. How will among agency disputes be resolved in terms of information sharing? I think ASEC Ronel can help us with this, or Sir Roy. How will among agency disputes be resolved in terms of information sharing?
Well, Ms. Camille, I would call on Mr. Oxon, our privacy expert, for this. In terms of the system, we've considered technically the escalation or referral in our system, and also we're targeting to have some sort of feedback from those agencies, part of the consumer net. Once we have already, they have already some sort of resolved the complaints. For some agencies, they're part of the consumer net. Actually, they're considering to be users of the system of the PODRS. So we'll have some sort of updates, and we'll know how a complaint is being resolved. But on a data privacy perspective, I would like to call on Mr. Oxon for this. Thank you.
Hello po. Hello, Ms. Camille. On that regard, primarily we need to inform all the registering complainants through the system that their personal information, at least a minimal part of their personal information, may be shared to other organizations, other agencies, especially when resolving complaints. At least at that end, to be transparent. That's one of the principles of privacy. But we would like to implement the least amount of information when sharing these information to external partners of DTI. Instead of sharing the entire content of the complaint, the entire information set of the complainant. So we would like yung minimal lang, kasi hindi makailangan siguro lahat malaman. And aside from that, having in place documents, siguro a MOA or a data sharing agreement, diba, that DTI will be sharing such information to other agencies, at least on the data privacy aspect. To immediately just answer yung question kanina na or regarding information shared. Tama po ba?
Yeah,
Ayun po.
I think so, Sir Buboy. Thank you. Thank you, Sir Buboy.
Thank you po.
PODRS, Sir Roy, maybe you can help us with this. How do we get the attendance in of online mediation? Will PODRS replace the existing complaints handling mechanism of DTI?
Actually, the people or mediation people who process these processors would be registered in the PODRS as users. So technically, the process itself will be handled within the system. So again, ICT is a tool for you to automate most of your processes. But then again, we would still consider some sort of business continuity plan just in case there's no system. Again, at the end of the day, what we're after is the welfare of our consumers. So we need to be ready for anything, especially if it's within the ODR or if the ODR PODRS is unavailable. Thank you, Ms. Camilo.
So will it replace the existing complaints handling mechanism? I don't think so.
No, it will complement it, actually.
Exactly. It will complement, because of course there's a transitioning phase, for us to do, so that we can be, we can fully implement this system that we are aspiring for. Okay, there's a question on what is the jurisdiction on complaints with parties residing in different territories or countries. Issues on jurisdiction and enforceability of online dispute resolution. I know that earlier Attorney Blakely has touched on this. Sir, maybe you can emphasize on this.
Well, it really depends on what we're talking about. I mean, if it was really an international company that used ODR, for example, they might require as their terms of usage that people consent, in various countries consent to the use of their ODR system, like, Alibaba or eBay or whatever. That could be one system. The other issue would be if it's like in the Philippines, if we're talking about the Philippine ODR system, it could be a combination of consent to jurisdiction through that system, but also the exercise of extraterritorial jurisdiction on the part of, through the ITA, through the Internet Transactions Act. And it could well be too that, companies which are very interested in working in the Philippines decide that they want to, not just have jurisdiction asserted over them, but they may want to affirmatively register to do business in the Philippines. And, I could see, for example, a potential requirement built into the Philippine ODR system in a combination with the ITA, with the Internet Transactions Act, if that were to become law, that it could be something like the EU, that if you are doing business as an e-commerce provider in the Philippines, that you consent to having your customers use the Philippine ODR system. And you might be required, for example, to inform your consumers of that, even if you're an international company. But I could see international companies, if they really do business in the Philippines on a regular basis, they may decide it may be to their benefit to register. And frankly, it may be to their benefit to do that because they want to cultivate an atmosphere of trust on the part of consumers. And a consumer, just as I was saying that consumers, if they have a bad experience on the Philippine ODR system, that will spread, that word will spread, it will become viral, and it will not be a good reputation. The same thing can happen to online providers. If they have a good reputation, or if people know that everybody makes a mistake. every company makes a mistake, always. The real issue is not whether you're going to make a mistake. The real question is how you treat your customers when you make a mistake. Do you treat them fairly? Do you provide a prompt refund? Do you provide them with recourse to an online dispute resolution that will make them happy? Because customers will remember that. They will remember how they were treated, and that will be the impression they have. So I think there's going to be every incentive for companies that do business in the Philippines and do business elsewhere to register in the Philippines and to encourage the use of the online dispute resolution system as a way of resolving those kind of complaints and building what that will do from the standpoint of the overall economy in the Philippines. Collectively, it will build consumer trust in the e-commerce system. It will be one factor that people use in learning to trust e-commerce, but it will also help individual companies, e-commerce platforms, et cetera, in building consumer trust with that particular company or that particular platform. So yeah, I mean, the fact of a cross-border transaction makes it a little bit more difficult, but as Don mentioned in his, and ASEAN mentioned, ASEAN is developing, sort of the idea is to have a regional cooperative online dispute resolution system so that people in different countries can feel, the whole ASEAN experience is built, the e-commerce agreement, all of the interactions between the ASEAN nations are built on forming a regional network, a cooperative economic regional network that consists of a variety of components, e-commerce, online dispute resolution mechanisms, cross-border trade. That's very much at the heart of the ASEAN concept. And so I think that there's every reason to believe that there will be a lot of factors operating in favor of recognizing cross-border transactions and in fact encouraging them as the ASEAN nations sort of encourage economic interdependence and mutual economic growth and development.
Ms. Camille?
Yes, sir. Yes, Attorney.
Yeah, I agree with everything Craig said. Just wanted to add that I think the issue of jurisdiction is already existing at this time. We have that problem because internet transactions are really growing in number as well as in the value of the items being sold online. I think that having an online dispute resolution mechanism may even facilitate the resolution of disputes, notwithstanding the jurisdictional issues. As Craig said, the online sellers have reputations to protect, but if that requires them coming to the Philippines to appear before a mediator in person or attend a traditional litigation mechanism, then I don't think they would have time or resources to do that. But because we have an efficient online dispute resolution mechanism, they might even voluntarily participate in those dispute resolution mechanisms, regardless of the technical issues on jurisdiction. And I was looking at the ASEAN ADR guidelines. There was also like a distinction there between disputes which are domestic and international or cross-border. So I think the PODRS can also take note of that distinction, because for cross-border disputes, then it may be advisable to, for example, recommend a commercial ADR at the first instance, or as I mentioned earlier, try to integrate the ODR platform of the system of the online platform, because they might be able to help resolve that dispute at that stage. So it doesn't even go to the stage where the DTI needs to administratively resolve the dispute.
There's another thought that I had, which I'd like to throw in here, and that is the idea of mutual recognition of other countries' ODR systems. I mean, if the Philippines has an ODR system and some other country, China, Korea, whatever, a nearby country has an ODR system, and they agree, they sign mutual recognition agreements, they agree to accept the results of each one's ODR system, that would also be a way of dealing with some of these jurisdictional issues, and it would be very consistent with the ASEAN goal of encouraging economic interdependence and interconnectivity.
That's very true. Thank you, Attorney Blakely and Attorney Calimon. All right. we have a lot of questions. Time check is 11:53. Maybe we can have 3 or 4 questions. And then for the other questions that we will not be able to respond to this morning, we will collect them, and then we will request our presenters to through email to help us address these questions. And then we will get back to our group chat and send them to you, our participants, and for you to know the answers to these questions. All right, let us proceed. What is the national or local agency that is mandated by law to handle and settle said online disputes? Tony Karimon?
In the Philippines, we don't have. We have a general ADR framework, but we don't have specific, aside from the PODRS under DAO 20-05 of the DTI, we don't have any specific law or regulation on online dispute resolution. So in terms of like agency that is mandated to handle it, I'm not aware of any. So, but in terms of private institutions, as I mentioned, private ADR institutions in the Philippines, like the Philippine Dispute Resolution Center or the PICCR, handle those types of disputes if there's an agreement by the parties.
Thank you, sir. ASEC Ronel, maybe you can share what FTEB is doing, or the ROG, if he's not in the other meeting. Sir? Oh, all right. I'm sorry, but I think he's quite busy with the other meeting that he has. If ever there's we have any official from FTEB who can, or ROG, who can share with us, please feel free to do so. Just raise your hand or give me a buzz so I can call you. Let us proceed to the other questions. Or what could be the time frame or timeline in accomplishing or finalizing the PODRS? I'd like to answer it, but may I call on Sir Roy or Sir Dr. Mario, please?
Thank you, Camille. We are response, so we're just responding to requests. And the timeline that's given to us is March to have this live system working. But we expect that there will be a quite much longer transition because you know, our citizens have inertia when it comes to using new technologies. But as Roy had mentioned, I think DTI's policy is as much as possible to ensure that we accommodate complaints in whatever platforms they use, and then we try to promote the use of the PODRS. So as our chief of party had said, yes, so it's March. So we will comply with that directive. Thank you.
Thank you, Doc Mar. All right, okay. We are all partners here, and of course, I would like to say that we would like to see it functioning, no, by next year. Yeah. Okay, I feel nervous, but confident in a way. All right. The next question. Will the PODRS cover business-to-business transactions? May I call Sir Roy, please? Will the PODRS cover business-to-business transactions?
Actually, one is we're talking about consumer here.
Mm-hmm.
So based on the laws, the thing is that we're still coming up with the guidelines, especially with the help of CPAB, on with what to on how to use this system. But then again, we're talking about consumers here. So definitely it's B2C, business to consumer. I think Ms. Camille, am I correct that business to business will still would be catered as long as there's a representative approved by of course during the registration on the system. So there are some exceptions like one-offs that would be defined in the guideline as well that would not be covered in the PODRS. So definitely the PODRS will be able to be transparent in terms of what is covered by the system, by the process of DTI. So, thank you, Ms. Camille.
Thank you, Sir Roy. Okay, I just have one last question for our presenters. Let's see. For Attorney Calimon, please, how would you recommend that the hybrid commercial administrative ADR be affected in the PODRS on the matters of appeal, since the commercial ADR does not consider appeal, while in administrative ADR, appeal is an option for the parties? This is on the matter also of private mediators.
Okay, thank you, Ms. Camille, and thank you for the question. I think at what I was thinking is, and I also saw from the chat that there were questions or concerns about the number of cases that will come in if we implement this PODRS. So what I was thinking of was at the beginning of that process, the online system will determine from the answers or the information provided by the complainant, is there like an agreement to a particular dispute resolution mechanism? Because some platforms or some transactions may actually provide for a particular dispute resolution mechanism. So if there's none, then maybe the system, there will be a way for the system to determine if the complainant would be willing to, for example, submit it to commercial mediation, or otherwise. If the complainant is willing to submit it to commercial mediation, then actually that's one case which is possibly being removed from the possible number of cases that the DTI will handle. So if the respondent agrees to commercial mediation, then the system may automatically appoint a private mediator. And then once the mediator concludes the mediation, the settlement agreement will be forwarded to the parties. And I don't know if this is something that will also be shared with the DTI. But the parties can opt to deposit it in court, as I mentioned earlier. And then in that situation, the DTI administrative process is actually taken out of the equation. So that process takes a life of its own. But if they don't want commercial mediation, then that's when the other route will take place, which is administrative mediation before the DTI. And in that situation, it will take another procedure. And as mentioned by Ms. Calleja, it will be like there will be administrative appeals after the DTI mediation.
Yeah. Thank you, Attorney Calimon. I guess it's one of the partnerships that we would like to build, no? In creating at the same time in implementing the PODRS. We know that the government cannot do it alone. So it's important that we work together, all right? So we can serve our consumers. Attorney Blakely, just one last question. In the US, were you able to have private mediators in the ODRS?
Yes, there are a whole range of things that are available, but yes, that is available.
Okay, thank you. Thank you, Attorney Blakely, Attorney Calimon, ASEC Ronel, of course, Dr. Mario, Sir Roy, and Sir Buboy. It's unfortunate that we have no more time for this act. In fact, we have extended up to 12 noon right now. But we thank you, everybody, to our speakers, our presenters. Let's give them a big hand.
Thank you. Thank you very much, Ms. Camille.
Thank you, Ms. Camille.
To our participants who have stayed with us and listened to us and learned. I'm sure you have learned and relearned this morning as much as I did. So thank you very much for attending our forum for this morning. To close our forum, I would like, of course, to call on our partner in this project, Dr. Mario Lamberte. Sir?
Thank you, Camille. I would like to summarize the discussion because I might bring up a lot of issues that would be subject to dispute resolution later on. So I will not do that, but instead first, I would like to point out that this is really a project of DTI. The trigger point was the Department Administrative Order that was issued early this year. And it happens that we were also working on the Internet Transactions Act. And one of the provisions there is the online dispute resolution mechanism. And it also happens that we just came from an experience with credit information system where we evaluated their online dispute resolution mechanism to find out whether they can comply with the ARTA 3720 rule. So I think that's where we coming from. So from the challenge posed to us by DTI, specifically using root, we came up with a team to start assessing the existing mechanisms at DTI and then move forward to functional specifications where we consulted. In fact, both government agencies and the various offices of DTI all over the country, and also private stakeholders regarding the kind of PODRS that they would like to have. So we were so grateful to DTI, the staff that's working on this, and to the participants of those workshops who eagerly pointed out a number of issues that should be included in the future. Now, there's more challenge that we ought to face, looking at the issues discussed by Attorney Kalimon and Craig. So I think the first thing that we ought to do is to look at our results of the workshops and then find out what are the issues that need to be incorporated out of the issues that came out from the forum this morning. So with that, I would like to thank, of course, the speakers, Attorney Kalimon and Attorney Blakely, for graciously joining this forum and sharing with us their ideas and experiences in establishing an ODR system, especially pointing out some features that might be useful to the PODRS. Of course, we have to thank our other partners. The silent partner is the US-ASEAN Business Council, and through Maxi Magsaysay Kribesa, we were able to find the best person from the Philippines who can work on this, and they're able to share with us Attorney Kalimon. And of course, the other USAID projects, Pro-ICT, shared with us their expert on this issue, and that's Attorney Craig Blakely. So we thank all of our speakers and partners. We thank all our participants. Now, moving forward, our phase 3 team is already on standby. In fact, 2 of them are already on board. We already started with data privacy specialist because that's so important in this system. We have to assure our users of PODRC that they can trust the system when it comes to data privacy, and ensure that we comply with existing laws. So we move to phase 3, hopefully by mid-December, so we can catch up with the deadline given to us in March. But along the way, I would like to tell the participants that we will be consulting with you. So every now and then, because there might be some issues that we think that your ideas might be able to contribute to the resolution of those issues. So with that, on behalf of our partners, DTI, the ASEAN, the U.S. ASEAN Business Council, and of course, members of the Consumer Net, let me thank you for joining this forum. This is a really very productive forum. Thank you so much.
Thank you, Dr. Mario Lamberte, the team leader for the UPAF Respond. No? And so this is the end of the forum, but of course, we will be seeing you in other assemblies that we have regarding the PODRS. We have, yes, ended the phase 2, but we will be beginning very soon our phase 3. So this is not the last time that you will see each one of us. We will be requesting, as Dr. Mario has said, requesting each of you to help us again, support us and cooperate with us for us to create and implement the Philippine Online Dispute Resolution System. At this point, I would like to thank our partners who have given us the opening messages, Sir J. De Quiros of USAID, of course, our Undersecretary, Attorney Ruth B. Castello of the DTI-CPG, the Chief of Party of UPAF Respond, Dr. Enrico Basilio, and for our presenters, we had Attorney Anne Claire Cabochan, we had Attorney Don Mark Calimon of the ASEAN Business Council, also Attorney Craig Blakely of the Alliance Law Group LLC USA, and of course, ASEC Ronel Abrenica of the DTI-CPG. So thank you very much on behalf of our DTI UPAF Respond team. Maraming salamat po. Have a nice day and see you soon, everyone. Ingat po. Bye.
Thank you po.
Thank you.
Thank you.
Happy lunch.
Yeah, happy lunch. Sir Ron, let's have a briefer. Minutes.
We'll do that with me and Cheryl, Miss Camille.
Yes, yes. And of course, from our team, Alex, Aaron.
Copy, ma'am.
Bea. Who else there? And of course, Jobel, John, Doc Mario.
Yeah. So we'll schedule a team meeting with DTI next week.